Alrighty, so happy Friday, Floyd.
Yeah, happy Friday.
How are you today?
I'm glad the week is over for sure.
So, are we wearing our grumpy pants or our
Yeah,
nice pants?
we'll see how it goes.
Okay,
Good
okay.
week.
So, my name is Christine Jimenez. I am an attorney over in Texas, and you are?
I am Josh Floyd. I am also an attorney in Texas.
And every Friday we come together. It's either myself and Floyd, or it's some other members of our team, or another attorney, or old clients. And we host this program called the Consultation. And essentially what we do is pertaining to family law and criminal defense. Can you hear me?
You keep freezing up, but yeah.
Yeah, I just got your internet connection is unstable thing. So every Friday we come together and we talk through complex legal issues, fact patterns, and do our best to try to provide insight. I tell everyone at the beginning, middle, and end, please, please, please do not accept this as legal advice. Okay, what you're going to find as we are going through these fact patterns is that the smallest little nuance can change our overall opinion about the case. And it will change how we potentially, maneuver, how we answer things. And so if you find yourself in a situation where you might need a family law attorney or a criminal defense attorney, please hire an attorney in your area that practices in front of your judge. And do what they tell you. And hopefully this information will give you a little bit of, insight into what questions you should be asking and what your attorney might want to do. But ultimately, they need to be the ones that are proffering all that information. Cool?
Yeah. Do you know where people might be able to find this?
Freaking knew it, dude. I freaking knew it. So I don't know, Floyd, can you tell us where they might be able to find
I
it?
can, right? You can find us on Facebook if you
Okay.
want to look there, or any other social media platform. LinkedIn, Twitter, Instagram, TikTok. What are the other ones?
Yeah, exactly. I'm looking at my cheat sheet too. YouTube.
Is that social media? You can certainly find us there. You can find us on the World Wide Web at jimenezfirm.com.
Okay. Awesome. Okay, continuing on. First question, Floyd.
Snapchat? Are we on Snapchat? Or
I don't think you can post things on Snapchat. You're such an old man.
no, I am.
Like as a social media, like as a company, I don't know that that's a thing. Is it a thing? I don't use Snapchat.
OnlyFans? No OnlyFans. Okay.
No, Floyd. Oh my gosh. No.
Okay.
Let's
Cool.
move on to the first question, please.
Good idea.
Okay. Are you reading or am I?
I'll read.
It must be a bad question.
It's not a bad one. It's just going to go 15 different directions. So how can I file for full custody of my child and not allow the person to have visitation rights? I'm going through divorce. My soon-to-be ex-husband hasn't been there for my kid or anything. He also cheated and got another girl pregnant. How can I go about getting full custody and getting alimony from him? Yeah.
I mean, okay. So. I guess should we talk conservatorship first? And
yeah, I mean, what does full custody mean?
I don't know. I don't know what it means to her.
You do know what it means to her?
I do not know what it means to her. That's what I'm saying. And that's always the thing. Like, so people will come into the office and say, well, I want full custody. Okay, well, what does that mean? I think most people perceive that to mean that he basically has no rights for anything, no visitation rights, no nothing, right? Isn't that what you think?
No, I feel like full custody means like custody, like I want the child with me.
But she doesn't want him to see the child at all and not allow the person to have visitation rights.
Yeah, okay. So yeah, that's probably what she means by full custody.
Okay, so let's go under the presumption that she doesn't want anything to have dad. She does not want dad to have anything to do with the kiddo. That would be a termination.
Doesn't
And
have to be.
well, so it doesn't have to be, but in all probability, can do you want to answer the question? Would you like?
No. I just want you to answer it
Go
correctly.
ahead. Go ahead.
We have viewers that are here for correct legal advice
It was not legal advice. Did you not hear the
or
disclaimer?
correct legal analysis. And she doesn't say anything about a termination. She just doesn't want him to have visitation rights.
Okay, so if she just doesn't want him to have any visitation rights, that's also not probable. None of this is probable. This is not a good question. I think we should move on. Next question. So, okay, here's the thing, and I have to have these tough conversations with clients all the time. She's obviously upset because he cheated on her. And now he has another girl pregnant, and he hasn't been there for her kiddo. And I understand the whole being a bad husband thing, but that doesn't necessarily mean that he's a bad father. And I say that because that's what most courts are going to find, right? Like they're going to say he obviously wasn't a good spouse, partner, whatever. Doesn't mean that he shouldn't have visitation rights with this kiddo. Now, if I were reading this question and there was all sorts of, family violence, physical abuse, psychological abuse, drug use, like craziness that was going on, then I think my answer would be different. But what I'm understanding at this point is it's just, I'm pissed off. He cheated on me. Another girl's pregnant and he hasn't been there for my kid. What does that even mean? Like he's not paying child support, not paying as much child support.
That was kind of my question is was he there for your kid before he had the affair? And then it's just afterwards that he's now not a good father? Because if he wasn't a good father before, you should have left him before, probably.
And I mean, the thing is I know like, it's very easy for me to like sit here and say it like as the attorney, right? As a woman, I get it. I totally get it. But as an attorney, I have to look at things from the perspective of what is the judge going to think and how is this going to be perceived by that particular court, right? They're not necessarily going to care. They're not going to deny him access because of this, barring something else that maybe you didn't put in the question, right? And so normally what is going to happen in this type of situation is you're going to end up with joint managing conservatorship. That means that both parents are going to have equal rights to information and to make decisions about the kiddo, right? And depending on the age of the child, he will likely get standard possession, right? I have seen judges in the past do things like an injunction prohibiting the girlfriend from being around the kiddo at least while the divorce is pending, right? Because I think most judges kind of understand like that's not healthy for the child. So you could probably get something like that. The other thing that you could maybe try to do, which is where I was originally going before I was so rudely interrupted, you could try to see if he would want to do a termination, right? Because sometimes if the fathers really don't want to be a part of the kiddo's life and they want to move on with their mistress and their new baby and start their new family, a lot of times they will just say, okay, I'll give up my rights to the kiddo. Now, it also says that she's concerned about alimony or spousal support, which leads me to believe that she probably needs child support too. So that may not be a good deal because most of the time, if he has visitation or if he has rights, he's gonna, if he terminates, he's not gonna pay child support.
Get it together.
It's been a long week, Floyd.
It has been a long 2 weeks.
2 weeks, yes. I'm glitching. So if you terminate his rights, you're not going to get child support, which may also cause problems. But if dad doesn't want to sign his rights over, then he's gonna get visits. And I don't know what else to say.
So there is a way that without terminating his rights, that the court can deny him all possession and access. You should be familiar with this.
Ha ha ha. Not under this fact pattern, Floyd.
Not under this fact pattern, but it is a possibility.
Go ahead. I'm too salty about it, so you can talk about that. I'm gonna actually turn my video off and mute myself while you do this.
So in very rare, by rare I mean you've seen it once, right, Christina? I think.
Oh.
I don't know how many cases we've handled, thousands and thousands. We've seen it one time where a judge did outright deny possession and access. So if you can prove that the child will suffer serious and irreparable harm if the parent is allowed possession over access to the child, then you can ask the court to deny all possession and access, and also remove all conservatorship rights. It's the same burden for both. It's happened, in one case. It was a pretty extreme. We can't go into the details of it, right? I mean,
You cannot.
Gruesome.
Very gruesome. Very bad.
And that's the only time that we've ever seen it. So the probability of this nice young lady having the same results is slim to none. Now, let's presume that the mistress just got out of prison for murder of children, right?
Now who's switching up the fact pattern? Okay, go ahead.
Then you will likely get an injunction against girlfriend. But I don't know that terminates dad's rights, where it all interferes with his visitation as long as he keeps girlfriend away.
Well, and then the courts also have to set up visits in the least restrictive means to keep the kiddo safe, right? And so a lot of times, like if there's drug history or there's something like that, then they'll send people to a facility. And they'll have supervised visits for a couple of hours, 3 or 4 times a month. That's pretty standard. And that's why, Floyd says it's extremely rare. It has to be like a crazy, crazy fact pattern for a judge to not even grant that. And so, yeah, that's probably not going to happen here. And so anytime I have clients that are in this situation, and it's not always the women, a lot of times it's the men. And actually, I think it's worse for the men whose wives cheat and then leave the kiddos, because we've seen that quite a bit. I try to encourage them to get in therapy and kind of deal with those issues, but to not try to hurt the other parent by using your kiddos as a pawn because you're pissed off that they cheated and they left you, right? It never ends well, because I can understand the pain, but when you go and you present that in court, we're not going to win. You're not going to win it. The judge will be sympathetic, empathetic, but you're not going to win. And so it's a waste of time, energy. And so you got to just deal with that with a counselor, and they'll be much cheaper than attorneys 99% of the time.
And an advantage we have, and I guess the judge too, is we think about it from a logical perspective, not an emotional, I hate this jerk, I want to get back with him and get back at him any way I can. Not with him probably, but get back at him. Maybe. And unfortunately, sometimes kids get stuck in the middle of that, trying to hurt the other parent because they hurt you. It's not ever a good move. And at the end of the day, the court's only consideration in visitation is best interest of the child. Doesn't really give a shit if you're hurt or what happened. Can we say shit?
Well, I hope so. You've said it twice now.
Can we say it? Okay. So yeah, they don't really care. Because like Christina said, that makes him a bad husband, right? Not a bad father. And so the court's going to do what's best for the child, regardless of how you feel about it.
It sucks, dude.
I don't know. I think it's the right way to think about it.
I mean, yeah, if it doesn't happen to you, but if it happens to you, like that's, I don't know. If you're married and your husband has an affair, I mean, he's not a good husband, but he's also kind of doing that to the kiddos. No, like, I mean, he's leaving the kiddos to be with this other woman and like breaking the family apart. That sucks.
I didn't say that it doesn't suck, right?
Sucks.
But you still have to look out for the kiddos.
Yeah, and I mean, it depends on dad too, because we've seen that happen a ton of times where literally he goes off, he has this affair, and he abandons the entire family. Like that's not he's a bad husband situation. He's a bad human situation. And in those types of scenarios, I think you can make this argument of he abandoned us, we don't have financial support, he hasn't tried to see the children, he doesn't care about the children. And you can get restricted access, but that's kind of difficult to do even then. I do think, I guess let's talk spousal support.
See,
You want to talk to that?
yeah, I can talk to that. So spousal support in Texas, you only qualify if you have insufficient means to provide for your minimum necessities. So do you have a place to live? You have food and you have clothes, then you're good, right? They don't like it really in Texas. It's different at temporary and final. Temporary, it's easier to get. Final, you have to be married 10 years before you can get it, or 3 years, and there's been family violence, but there's none here that we know of. So if you haven't been married for 10 years, you're not going to get spouse support at final, but you can still get it at temporary. And certainly the fact that he had an affair plays a big role in a judge's decision to award spousal, and the fact that he got another girl pregnant. Courts don't really like parents abandoning one family to start another one, right? They're not going to let them do that. And so they're not going to like the excuse of I can't afford spousal because I got to pay for my new mistress, and baby, it's not going to go over very well. So you probably get some spousal support depending on what your income looks like.
And child support. And I would go ahead and throw your therapy sessions onto your financial information statement. So that way maybe you can get help with that too. And you just got to focus on healing. Like, and that's the thing that I try to tell people all the time is this process, this divorce process, I would not wish it on my worst enemy. I wouldn't, because it is hard. It is emotionally, financially, mentally, like any type of draining that you could have. That's what it's going to do to you. It drains you. It drains us sometimes, and we're not actually going through the process. And so what you have to do is you have to figure out a way to make the best out of a terrible situation, get past it, get as much as you possibly can to make sure that you are okay. And then you're done. So she needs to focus on healing herself. And I think this whole process will be much easier for her. And she'll probably end up with someone better anyway that would not have done this to her.
How's that expression goes? Plenty of fish in the sea.
Yes. Yes. Next question.
Sure.
What are my rights if I sign them over temporarily? I signed my child rights over to my sister temporarily, supposedly, and I have to pay $200 a month for child support, but hardly see him because she's taking the order and running with it. I want to change it.
Well, I don't know the answer to that question because I don't know what your order says. By signing your rights over, I presume we just gave sister primary?
Yeah, that's what I'm going to go with because he's paying child support and has visitation.
Well, maybe it's a she.
Or she, correct.
Yeah, I'm gonna go with it's a she.
Okay.
Okay, so so if she signed primary over, it depends. She doesn't know if it's temporary, right?
Dude,
So,
we're so exhausted. I need my Red Bull. I need something. We're so tired.
it's been rough. we were gone a CLE for a week, and then we come back and hell breaks loose. It's just been.
You know that we did twice as much work. Like we caught up. We did as much work from the week that we were out, and then we came back and we did that in 1 week last week. And then this week was like a continuation of chaos. I don't know what's happening. Like people are going back to school, summer's over, but I'm just gonna need everybody just to chill out for a little bit. Like take a minute, take a break. It's gonna be okay. But yeah, we're tired. Sorry.
Yeah, so we don't know if it's temporary or final because it's supposedly temporary. And so let's say that it is temporary.
Okay.
Then what you need to do is just go back to court, right? I mean, depending on the circumstances, why you sign them over, if everything's been corrected in your world or whatever the facts were, I don't know why you sign them over. Maybe you just needed a few months to get your shit together. I can say it. Julie confirmed that she texted me and said, you just can't say the B word.
No, that's because Julie said the B word a couple weeks ago, and then I gave her a face. And so, yeah, but no, I don't know that you can say any of those words. So,
okay, I will try to avoid it.
Okay,
make no guarantees. Anyway, you got your crap together. Crap, cool. Okay.
Crap is good.
All right, you needed a few months to get your crap together. You got that together. You can go back to court. And
wait, is it true that you and Sarabia had a side bet on how many times I would say crap on Facebook Live?
Wait, was it crap? We did have a side bet on something, but it may have been crap.
Crap. I don't remember, but I remember Sarabia told me, I was like, y'all are a bunch of assholes.
What?
We could say ass. We'll go with ass.
So we can say the words that you say, not the words I say. Got
right.
it. Okay.
That's like standard in everything we do. So, okay, go ahead.
So, well, never mind, it's bad. Anyways, so there's a parental presumption that you should be able to raise your children. And so if your circumstances are such now that you are able to do so without placing them in any type of danger or anything like that, and able to provide for them, then you should be able to go back to court and get your kiddo back.
But wait, so, okay. If there's two types of orders that you could potentially, well, not only, but most of the time that are signed. The first is going to be a temporary order, and the second is going to be a final order. Okay. And so if you signed a final order giving your sister temporary conservatorship over your kiddo, then he's going to be, or she's going to be locked. Well, because they may have, Floyd, we're not talking lawyers here, right? I understand that doesn't make sense, but we've seen it happen where the sister's like, well, no, it's just for a year. Just sign this final order, or it's just for 6 months. But once you get your crap together, I'll give you the kid back, right? And these people, they don't know what they're signing. And we've had that happen. So if you signed a final order, then you're going to be locked into that for a year unless you can prove that the kiddo's in danger, or the child's 12 years of age or older and wants to come live with you. I always get confused. So if I'm wrong, I'm okay with that.
You're right.
Is it right?
If the sister gives them back.
Right, or if it's voluntary relinquishment, 6 months or more, right? And so, but if it was a final order, then you're locked in. Not a whole lot you can do. If it was a temporary order, then you can file a motion to modify that temporary order, and you can go in and say, listen, I made a mistake, or I did it, it was only supposed to be for 30 days or whatever it is. And then the court at that point can grant a new temporary order, a modified temporary order, giving you your kiddo back. The other thing that I would look at if I were hired on this is, did the sister have standing when she filed? Right? Because if she didn't have standing when she filed, even if our client consented on a temporary order, we could challenge standing at any time.
Can you after they consent? So maybe if it's if she had filed,
Mhm.
I've been the one that filed, you couldn't challenge it.
Right.
Is
But
there's
if
not a consent?
I don't think so. I don't think the mere fact that she signed an agreed temporary order would be that she's consenting to standing. And I guess that would have to be something that we would want to research. But so that would be something that I would want to look at. And then, so basically standing is just a person's legal right to step in and actually litigate or fight for a kiddo, right? And there's certain things that have to happen, like significant impairment. They've had to have possession. There's all sorts of different ways that you can get standing. And so if the sister didn't have standing, maybe that's a way that we challenge it. Like Floyd said, you have the parental presumption, which is always going to be super helpful. But yeah, hopefully it was just a temporary order, or hopefully it was just like a notarized document of some sort. And if that was the case.
That was my thought initially, and then she said taking the order and running with it. And
Yeah,
then she has to pay child support $200 a month. So my guess is there's an order, hopefully a temporary order, and it can be fixed.
yeah. Don't sign your rights over. That's a good rule of thumb. Don't give other people rights to your kiddos.
It is a good rule of thumb.
Correct.
Okay, I'll read the next one. How to divorce a non-citizen. My non-citizen husband and I have been married for almost 2 years, and since we had our interview with USCIS for permanent residency adjustment, he has been abusive mentally and verbally and has been drinking very heavily. Spends little time at home, doesn't spend any time with me, barely speaks English, and now wanting out of the marriage, threatening me with finding elsewhere to live, even though I do not have a job. What can I do legally to get this divorce started? What are my rights? I have proof of his abuse and unwillingness to speak face to face. He thinks that we can just separate and let that be that and not get a divorce because it could mess up his green card.
You just divorced him, right? I mean, just file the petition for divorce.
Yeah.
And be done with it. And if it messes up his green cards, well, maybe he shouldn't have been such a jerk. Right?
Yeah, that's on him.
Question. Done. No, seriously, we're done with the question.
Yeah,
Is there
no, that's
anything?
it. No, just normal divorce.
Yeah, I thought that this was gonna be like he fled to Mexico and we can't find him. I thought it was gonna be a service thing. Yeah, isn't there something, and I don't know, like, isn't there something that when you sponsor somebody's green card, like there's fees or something associated with it if you like want to rescind it or something? What is that? You know what I'm talking about?
Yeah, so I think it's that when you sponsor them, you're financially responsible for them, right?
Mhm.
And so if he were to get any type of government assistance, you would be responsible for reimbursing the government for whatever it cost him. Whether or not he gets to stay in the country after the divorce is really up to them, the immigration folks. If they believe that he married you just to gain citizenship, they can remove him. But that's everything I know. I'm sure there's a lot more to it than that, but
Yeah, we don't do any sort of immigration law. We know a couple of attorneys that are really good at it. And so we would call them and say, how does this work? And they would tell us. But yeah, just file for divorce and get him out of the house and get away from him. So next question.
well, I guess so. She says he thinks we can just separate and let that be that and not get a divorce. What are your thoughts on that?
Are you talking about so you don't have to worry about the government assistance stuff and all that crap? Or just like separating and just,
Not getting a divorce in general,
why would she ever do that?
so it doesn't mess up his green card.
Why does she care about that? He's an abusive alcoholic that doesn't come home.
Don't know. He doesn't come home.
He's
Threatening her with finding elsewhere to live, even though she doesn't have a job.
oh, so she needs him.
and she hasn't been married 3 years.
Spends little time at home. Floyd, is it 3 years for the family violence thing? I thought it was 2 years.
I thought it was 3.
Okay.
I know who can tell us.
I thought it was just that family violence had occurred in the preceding 2 years prior to filing. And that was sufficient. I don't think that there was a time requirement that they had to be married. It was just that it had occurred.
I think it's 3 years, but I'll let you know momentarily. Just ramble like you normally do, and I'll get you an answer.
I got this. I got this. So yeah, this situation actually really sucks now that I'm understanding. For whatever reason, I was thinking that she was the one that was doing well and he was not coming home and he was doing his craziness stuff. And he wasn't working and he was an alcoholic, etc. Yeah, I mean, if you divorce him and he loses his green card, then you have no means of support. You won't be able to get any sort of spousal maintenance or anything like that. I don't see that they have any kiddos. Yeah, that's just a really tough situation. It's going to be a tough personal decision that you're going to have to make. If you file, then it's going to cause immigration consequences, which is also going to cause financial consequences, which means that you may have to go get a job or figure something else out. But if he's abusive and he's doing all this stuff, you probably need to do that anyway. So what are you looking at, Floyd?
Looking at the spousal support statute.
It's there. No?
Yeah.
Is it because I'm right and you're trying to figure out a way that I'm wrong? I think that's what's happening here. Hence
No, I can't even find the 10-year one.
So chapter 8, maintenance, eligibility, for maintenance. So the spouse from whom maintenance is requested was convicted of or received deferred adjudication for a criminal offense that also constitutes an act of family violence committed during the marriage against the other spouse or the other spouse's child, and the offense occurred within 2 years before the date on which the suit is filed or while the suit is pending. It's 8.051.
No, I saw that, but that doesn't state the 10-year thing.
It does, subpart 2. And that's actually something that I forget a lot is or the spouse's child. I always think about family violence against the spouse, but not the spouse's child. So something that we need to remember.
Yeah, so where did I get that 3-year thing from?
I don't know. So that's what happened is you were trying to prove me wrong and you were like, oh, where is it? Can we just notate for the record? I was right.
There's on one occasion. But you were correct.
Yeah, I gotta own it. I gotta be like proud of that. So, okay, next question.
I guess so. I'm gonna have to look at that. I swear.
I don't remember anything on 3 years, Floyd.
Well, maybe it's the law according to Josh.
Okay, interesting. Okay, next question. Oh, this is a good one. What can I do to get my physically abusive boyfriend out of my house? I moved in 3 years ago and he has not worked or helped me with anything. He beats me and threatened to kill me and hurt my family, then tells me I can't make him leave. What can I do?
Call the police.
Okay, and what else could she do?
She could also file for protective order. That's it. Here you go. Next one.
Explain how all that works, fool.
All right. So you pick up the phone, dial 911, let the police know that you're an emergency, and then they come to your house. and you tell them that he's been beating you and he's threatened to kill you, and then they arrest him for assault, family violence, maybe terroristic threat. If he tries to take the phone away, maybe interference with 911 call, and he goes to jail. And then before he gets out, you'll be issued an EPO, emergency protective order, where basically the magistrate issues a protective order and says he can't come around you for 30, 60, 90 days, come back to the house or anything like that. And then after that's been issued, then you go hire some great attorneys that are familiar with protective orders in the area in which your case is going to be litigated. And then they'll file for a 2-year protective order, likely request an ex parte protective order, which is very similar to an emergency protective order, almost identical. It lasts for 20 days.
Yeah, I think it's 21.
Somewhere along those lines. And then you'll have a hearing during that interim period. And you'll put on evidence to show that, you know, he's abused you, that there's been family violence that is likely to occur in the future. And then the judge will issue a 2-year protective order. And then you're safe for 2 years. If he comes around at that point, he'll be catching another criminal charge. If you don't have him arrested, you can still file a protective order. It just skips all the 911 call and the emergency protective order. You go straight to an attorney and they can file a protective order requesting an ex parte protective order. And what's the burden? What's the burden for a kick out order? Substantial risk of blah, blah, blah.
I don't remember. It's that they've resided together for the preceding 60 days and that there's substantial evidence, I don't remember, to show that family violence has occurred during that time period.
Okay, yeah. So there's some way you can get it, what we call a kick out order, which is in the ex parte protective order, the emergency protective order. The judge will sign an order requiring him to vacate the residence, but you have to show something in addition to family violence. I want to say that there's serious risk of substantial harm to the person or property or something like that.
So the court finds, based on the affidavit and testimony, the applicant resides on the premises, that respondent committed family violence against the applicant, a member of the household, within the 30-day period before the application was filed. There is a clear and present danger that respondent is likely to commit family violence against a member of the household.
Clear and present danger. Isn't that the name of a movie?
It is, yes.
Have you seen it?
No, I have not. I don't think. I shall Google. Isn't it Harrison Ford? It is Harrison Ford. 1994, Floyd, we're so old.
You are old. So yeah, protective orders, before we start talking about our age. And you can, you know, if you get the protective order granted, you can have him pay the fees, the attorney's fees, the filing fees, and all of that stuff. And do what you do.
So I guess let's talk a little bit about this idea of not calling the police, because we see that a lot.
Adverse to my advice.
I know, but we see it a whole lot. And I understand it. Like when I talk to our clients, and both male and female, that have been victims of family violence, it is a terrible situation that people find themselves in. And obviously the best thing and the safest thing to always do is to contact the police, but a lot of times people don't do it, Floyd. You know that. I mean, I can't even tell you the number of times we've had cases like that. And so, you know, in those situations, the hope is that we have some sort of recording. We get a lot of those, right, where they're recording and you can hear the scuffle, you can hear them breaking things, you can hear people falling, really bad, horrible things. or you have photos, right? Or you have a witness, like maybe you call somebody like when it happens, or you go to somebody's house and they see that you have a fresh bruise or a busted lip or something, and those people can come in and potentially testify. Or you can get this person to, after the event, admit that something happened. But I just don't want people to walk away with this idea of, well, I didn't call the police, so I can't potentially move forward with the protective order, because it happens so often that people don't do that. And so if you don't call the police, then you're going to be in a position where you're going to have to try to, gather up some sort of evidence to prove that it actually occurred. But even if you don't have that, and we've had that happen too, where we don't have the proof that it, photos, videos, or anything, we just have testimony. And your testimony is evidence, and the court can consider it, right? It comes down to a credibility issue. Is the judge going to believe you, or is she going to believe him? So obviously that's not what we prefer to do, but we've done it. And I think that there's been plenty of times where our client's story was so vivid and it was so compelling that judges granted it without any additional evidence. We had one where our client was assaulted in a parking lot, no witnesses, no police, no nothing. Was there a police report on that one? I didn't think there was. I don't know if you remember who I'm talking about, but I don't think that it was just her testimony.
Oh, yes, no police report.
And when she told the story, it was so powerful that there was no way that what she was claiming happened to her didn't happen. And we were able to get a protective order and make sure she was protected and our kiddo was protected and everything was good. So if you find yourself in a situation like this, go and talk to an attorney and tell them what has happened and tell them what you have, and try to get yourself out of the situation.
Do you think that not calling the police impacts the credibility of the story?
I think it depends on the judge.
On cross, the question is always, well, if you were in danger, you would have called the police. You didn't call the police. There's no, all that kind of crap, right?
I think it depends on the judge. I think that there are lots of judges that understand domestic violence. They understand the cycle. They understand positions that most of these people are in and why they choose to not do things. And I also think it depends on the alleged victim, right? There are some people that I talk to that claim that they're victims of family violence, and it's very difficult for me to believe that those things happen, just because the way that they present it just doesn't seem like they're being truthful. And I think that the courts take that into consideration. Your credibility is always going to be an issue when you walk into family court. And so, and obviously the reason why calling the police is so significant and important is because what you've done is you've gathered evidence. Right now we have police officers that'll come in and say, yep, she, had a bruise on her face and he had marks on his hands, and we have video recordings and admissions and all sorts of stuff. That is the best case scenario. But
because a lot of times you'll have, unfortunately, women that are being abused for years, right? And then they don't say anything about it until divorce, right? And so then it looks more retributive, right? Like, I'm accusing you of family violence because you filed for divorce. Isn't that a word? It's a damn word.
Is it a word? Retributive.
Someone throw me a lifeline here. This is a word.
Oh, wait, hold on. Retributive.
Retaliating to or intended to be deserved or severe punishment. That's your vocabulary lesson for the day.
No,
Retributive, yeah.
Okay, good word, Floyd.
Yeah, it's my Harvard education.
Continue.
So anyway.
Or retaliatory. I like retaliatory. Also, it could come off as being retaliatory because they're doing it during the divorce process. But okay, or retributive is a good word too. I like that word.
Thanks.
Okay.
You can use it sometimes, but anyway, so it comes off, it loses credibility because it comes off that way. And so that's another reason that calling the police is important, is because even if you're not getting divorced, right, you've got it on record that you made a report on that day, and it just lends more credibility to the issue. But with protective orders, the burden is just preponderance, right? It's not clear and convincing, is it?
I thought it was clear and convincing. I thought it was clear and
I'm
convincing.
going to bed.
Me too, Flying. We actually don't have any clue what we're talking about, like, ever.
Cool. Yeah.
Good talk. All right. Have a good week. See you in the unemployment line.
Right. You were talking about how to calculate child support? I think we could do that.
I don't know, dude. Right now, I might not be able to do that.
What is a child?
Gosh. Okay. So the other thing that I was going to mention that I see a lot, which is it's a weird kind of like phenomenon, is when like these women, it's typically women that have been in these relationships for years and years, and they've been abused for years and years. Have you ever noticed that they're very like just desensitized? Like when they're telling their story, they're like, yeah, he walked in and he punched me in the face, and I, fell because I didn't have dinner. Like when they tell the stories, it's so like
Dry.
yeah, it's just like a normal conversation. Like they don't realize, like, no, this is crazy. And that is always super frustrating and super concerning when I'm prepping them for testimony, because the immediate reaction of somebody who's never been in that situation is to think there's no way that it happened to you, because if so, you wouldn't tell your story that way. And so that affects people's credibility. And I wonder the number of times that women and men have walked into a courtroom with that, I don't know, demeanor, and were not believed by a judge, because it's hard to believe. Even when I'm like talking to them, I'm like, this doesn't make sense. Why are you so, what's the word?
Cool.
Yeah. Why are you so cool about this? But they are. So in those types of cases, when we don't have any other evidence, then credibility and testimony and being able to paint pictures is so important to that hearing. So, ¿qué más? What are you reading? What are you looking at?
I'm trying to figure out the burden on a protective order. I've got to learn this stuff. I don't know. It's all gone. Maybe I should learn next week.
We always, and I feel like I have to give disclaimers like now that people understand that we don't look at these questions before we start. And when we work on our cases, and we're preparing for hearings, we obviously have to sit down, we have to do the research, we have to look at the fact patterns, we look at burdens of proof, we look at all the elements of whatever it is that we're trying to prove, so that we are prepared. But we're not freaking cyborgs, Floyd. I don't think people expect that we're just gonna like bloop, 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 know all this stuff. Is that what you expect of yourself?
Yes, absolutely.
Well, you're better than me. I'll go and look it up.
It's true.
Did you find it?
No. I'll say it's true that I'm better than you.
This is a true statement. Yes, I'll give you that.
All aspects of life.
Preponderance of evidence favoring the accuser.
That's what I found, but you say you thought it was clear and convincing.
I did. I thought that, but that's not correct.
So if in fact it is really preponderance, it's a pretty low burden, right? It's just more likely than not.
You know why I think it's clear and convincing is because I never feel like that's the burden we're held to when we're defending, or representing the applicant. I always feel, because so once a protective order is granted, the person that has the protective order granted against him, they can no longer possess a firearm for the period of the protective order. And if they're caught to violate that protective order, they go straight to jail. And so my experience in the courtroom has been that judges are more inclined to not issue protective orders unless there's a firm belief or conviction that it has occurred. And that's why I thought it was. Yeah.
I mean, it probably should be, right? Preponderance of the evidence is just so small. But we're not here to advocate for this law to be re-legislated, or to be retributive or retaliatory. So
What your horns is like trying to poke itself out.
my alfalfa, today's the alfalfa day.
I can tell it's been a week. It has been a week.
It's a rough one.
So, okay, next question.
Yeah, so you're trying, I don't know whose turn it is to read.
Okay, I'll read. Texas OAG is making me attend a teleconference to renegotiate my child support, but my decree says otherwise. Can they? My decree states statement on guidelines. We stipulate that the amount of support is less than the statutory guideline based upon the division of the marital estate. Okay. And specifically the allocation of liabilities to blank herein. The parties further stipulate, and it is therefore ordered that the amount of child support set forth herein shall not be modified for a period of at least 5 years, beginning March 1, 2020. OAG is saying they're having me attend an online hearing with my ex-spouse to review because I'm due for one. I explained the decree and they said their legal team doesn't honor that verbiage. What's the point of a legal decree if the OAG won't honor it with my child support? Amen, brother. I agree. Can they override the decree?
Absolutely, they can, yeah. So
They
you can't, huh?
They can try. I don't know that they just can.
No, they can.
Are you talking about like retro support, or not retro, but like arrears? Or you're talking about like in this case, you don't think there's anything we can do about it?
No.
I say you're nuts.
I won't dispute that, but it doesn't affect what you can do in this case.
Okay, tell me.
So you're not allowed to make agreements that impede a court's ability to act in the best interest, i.e. child support, visitation, things like that. And so you can't limit a court's ability to you can't restrict their ability to modify orders relating to children. And so it's cute that it was put in there. The other attorney probably knew what the hell he was doing and knew it wouldn't have any impact. But
I don't think that if you were to file a response, so number one, not attend the teleconference to renegotiate. You don't have to, you're not ordered to. So yeah, don't do that. They'll file a motion, they'll set it for a hearing, and then you would show up. You don't think that if you were to show up and argue that response and basically state that the division of the marital estate was the offset of the support, you don't think judge would at least consider it and maybe rule in your favor?
I don't think the court would be allowed to consider it. I think maybe you have remedy under some type of contract law or civil suit where you come back and get damages for whatever it cost you in excess support that you had to pay because it was kind of a contractual agreement, which you can't make a contract regarding children, so it's void anyway. No, you're done. Toast. The other attorney wins. Check mark for him. You bit.
I mean, I would not. Well, so I will say that we have done this, but we set up other things that's basically punitive if they try to do something like this. And so if there's a way to do it, but I don't know. I think a lot of judges would say that it's not.
I mean, not if they really wanted to follow the law. You couldn't.
I don't know, Floyd. I think you could make an estoppel claim, or this isn't right. It's not right. it would not be right if she walked away, let's just say hypothetically speaking, with $500,000 in extra, funds from the marital estate in exchange for a reduction in support. I feel like an estoppel claim could be made and maybe a judge would consider it.
Unjust enrichment.
I don't know.
I believe recently you may have had a judge say, why would you do this? Or talking to opposing counsel, I don't remember who it was. Why would you ever negotiate property and child support together?
It was not my case. It was an attorney that called me and told me what happened. And I was like, ew.
Yeah, that judge was right.
Yeah, don't do that, attorneys, please. But I think I would still try to argue it. That's just not right. And shame on mom and I guess the attorneys for doing this, because that just really sucks. Or dad's attorney. That's not right. But you don't have to go to the teleconference. Yes, the AG can try. Yes, you should try to hire an attorney, not Floyd, to argue the unjust enrichment or estoppel or something. I don't know. We'd have to come up with something. But
you should come talk to me so I can tell you not to waste your money on any attorney that tells you they can do something about this.
You have to make the argument, Floyd. Oh my gosh, if I had a nickel for every time you told me, oh, we can't do anything about this. And then I'm like, no, we're gonna do something about this. And then you figure out a way. And then I
We've
know.
done a lot of research on this issue. And we came up with ways to make it work, but none of it is relying on an agreement. But
yeah.
So Natalie likes my word retributive. She's going to include that in her next affidavit, and Karina thinks that's a good idea. And then Ashlyn says, hi, Christina, and love you, daddy. She's talking to me.
Oh, hi, Ashlyn, my bestie. I hope you get to feeling better.
She said you look
Poor
beautiful
thing.
today, so her eyes are from the sinus infection.
You what?
She said you look beautiful today, so her sinus infection must be messing with her eyes.
You're such a jerk. Such a jerk. Okay, so I need to pull up the disclaimer. Sorry, I'm going. Ashlyn distracted me. I'm coming and go. Okay, so it's 12:59. As we say every day.
Every day?
Every Friday. This is not legal advice. Do not accept it as such. And I don't know that really any of this was any sort of good. Like maybe this entire thing should just be disregarded. Don't listen to it.
Delete this episode.
So don't accept this as legal advice. Find you a good attorney in the area where your case is going to be pending. Listen to them, tell them your story. And with that, I guess have a good weekend. Maybe we get some rest this weekend. No boat parties, no CLEs, no nothing. Just sleep. Yes. Okay, peace out.